This is what I love about Judicial Watch. It's like we don't stop. The election was done, and we're still fighting for election integrity. So Judicial Watch had a major development, or we engaged in a major piece of legal work this past week or so. We filed a Supreme Court petition on post-election day counting in Illinois. And I think we filed the case 2 years ago. And here's a summary of the issue that I put out there when we first filed it.
Hey everybody, do you think they should be counting ballots for up to 2 weeks after Election Day? Well, of course you don't. In Illinois, though, they count ballots that arrive for up to 14 days after Election Day, including ballots that don't have a postal mark on them. We're in federal court now trying to stop that because federal law requires an election day, not an election week, not an election month. And we got a federal appellate court hearing this week. Hopefully that court allows our case to proceed. In the meantime, we're doing heavy lifting down there in Mississippi, where they count ballots for up to 5 days after Election Day. Now, many other states, they also count ballots after Election Day, or ballots that arrive after Election Day, which is anathema to the very notion of fair and clean elections. It creates a mess, it invites voter fraud, it undermines voter confidence, and it's downright illegal.
Yeah, I mean, we had that big Fifth Circuit ruling in the Mississippi case and the circuit court agreed with us, the appellate court, that counting ballots after Election Day or received after Election Day is unlawful. And just counting, in my view, counting ballots generally after Election Day is unlawful, although no court specifically has agreed with me on that yet. But certainly counting ballots that arrive after Election Day is something that is contrary to plain federal law. And we see the chaos caused by, generally speaking, the counting of ballots after Election Day. In California, I checked the numbers just before I came on here. They have yet to count 315,000 ballots in California. Can you believe it? 315,000 ballots. Arizona, they went and counted ballots forever and a day after Election Day. I think it took well over a week for clarity to be brought to the Senate race. And of course, many people think the Senate race was compromised as a result of that past Election Day, post-Election Day counting. Illinois, as I note, 14 days after Election Day. And what happened in Illinois was the courts there were afraid to let the case proceed, really scandalously denied our clients the right to even bring the case by founding they didn't have any standing. On what earth would a judge think, frankly, and I have to be careful here because these are the judges and I don't want to get them mad at me and mad at Judicial Watch, right, and our clients. But the idea that a congressman running for public office and electors who were involved in the presidential contest wouldn't have the right to challenge illicit counting of ballots, it makes no sense. And of course, it's not the law. And that's why we filed the petition with the Supreme Court. And I'm going to read you the first few paragraphs of said petition. It was filed earlier this week. Here it is. You go to page 2 of the beginning of the petition. Statement of the case. For over 130 years, this court has heard claims brought by federal candidates challenging state time, place, or manner regulations affecting their federal elections. Until recently, it was axiomatic that the candidates had standing to challenge these regulations. Indeed, it's hard to imagine anyone who has a more particularized injury than a candidate has, we quote. That is because a candidate who pours money and sweat into a campaign, who spends time away from her job and family to traverse the campaign trail, and who puts her name on a ballot has an undeniably different and more particularized interest in the lawfulness of the election than some random voter. In the aftermath of the 2020 elections, however, for a variety of reasons, this is my editorial comment, Trump, courts have limited candidates' ability to challenge the electoral rules governing their campaigns. This case presents the latest and an extreme example of this trend. Petitioners are a sitting multi-term congressman, Congressman Bost, B-O-S-T, and 2 federal electors. They challenged an Illinois law that allows absentee ballots to be received and counted after the day specified in federal statutes for holding federal elections. They contend that Illinois receipt deadline, the election law, is preempted by the federal election day law standards. They asserted Article 3 standing, which is standing before the federal courts, on a number of grounds, including that they incur costs to run their campaigns for an additional 2 weeks to monitor ballot receipt and counting. Straightforward standing analysis. They got to spend more money. They also claimed a particular interest as candidates in an accurate tally of validly received votes. A divided panel of the Seventh Circuit, the Seventh Circuit Court of Appeals, which governs Illinois, or has Illinois in its jurisdiction, affirmed the district court's dismissal of the case for lack of standing. The majority held that the petitioners had not pleaded an injury in fact because, in the court's opinion, they did not need to conduct post-election monitoring of late arriving ballots in 2022, and thus any expenses incurred for monitoring were self-inflicted. I mean, that's just like Alice in Wonderland logic. Alice in Wonderland logic by the court to keep this case out. The court also declined to find standing because the 2024 election was then 2 months away. So it was too soon? So afterwards it's too late, and beforehand it's too soon. That's what happened in 2020 with the anti-Trump rulings by judges who were afraid to deal with the election controversies. Until this ruling, the only non-vacated circuit authorities to confront the question of candidate standing had held that candidates do have standing to contest violations of federal election law affecting their campaigns. Straightforward analysis. Petitioners respectfully submit that it is important, and this is key, for the court to correct the serious errors infecting the Seventh Circuit's ruling, especially those tending to foster an arbitrary approach to jurisdictional issues involving federal candidates. Again, this anti-Trump animus infecting other cases. They didn't like Trump messing around, challenging elections. That's my perception. And so our clients here challenge an obviously illegal law, post-election day counting of ballots received after election day, and they come up with this idea that candidates can't challenge that. If candidates can't, who can? It is also important that lower courts, potential litigants, and the public know that federal courts are open to hear timely, well-pleaded challenges to state time, place, and manner regulations. Federal court rulings on the merits, regardless of outcome, promote public confidence that federal elections are being conducted fairly, with integrity, and in accordance with the law. The petition presents an opportunity for the court to provide lower courts and litigants much-needed guidance on candidate standing outside of the high-stakes emergency post-election litigation where these issues commonly arise. That's why we asked them to grant cert, basically take up the case. So it's a good effort by our legal team. I mean, we had that major victory in the Fifth Circuit, and the Seventh Circuit doesn't want to deal with the merits. You know, taking on this, as we highlight in the brief, this increasingly restrictive view that candidates can't challenge elections, how they're run, and any illegalities associated with it. Now, how is that supposed to deal? If we can't use the law to resolve election disputes, then what do we do? And the court needs to step in our view, and fix it. And make it clear candidates can challenge elections in this manner or the way elections are conducted. We're not even challenging results. And now sometimes they say, well, this is just too run and gun. It's too close to the election. We're not going to intervene after the election and start throwing out election results. There's no excuse here. This is the straightforward case that at most would apply to 2024 at this stage. No, 2026. We just had the 2024 election. So the two questions I have for you, dear listener and dear viewer: A, do you think that states should follow federal law and only count ballots received by Election Day? And B, if they're not, should candidates have the standing to challenge it? And you don't have to be a lawyer to answer yes to both, right? Just common sense. So this is what I love about Judicial Watch. It's like we don't stop. The election was done, and we're still fighting for election integrity. A colleague of mine, a friend of mine, he said that in public policy, there are no intermissions. We're back to work. We're back to work for cleaner elections and the rule of law. And we're trying to get the courts to pay attention, rule, and stop using this standing scheme argument to prevent people from raising these issues in court. What a great little case that we're pursuing here. And obviously we're watching what's going on in California very carefully, and we may take some action there in terms of the post-election day counting. As I say in the release, it is a scandal that the courts would deny a federal candidate the ability to challenge an election provision that could lead to illegal votes being cast and counted. Illinois' 14-day extension of Election Day thwarts federal law, violates the civil rights of voters, and invites fraud. The Supreme Court should take up this case and reaffirm the right of federal candidates to challenge unlawful election schemes. So to bring you up to speed, in case you're not familiar with Judicial Watch's work, we have a numerous historic federal cases to clean up election rolls that in the last 2 years or so alone resulted in 4 million names being cleaned up. We achieved a massive victory in the Fifth Circuit Court of Appeals, finding as unlawful the counting of ballots, at least in Mississippi, that arrive after Election Day. We've got this major case in Illinois trying to defend the candidates who want to challenge laws like that in Illinois. And we have multiple lawsuits still to clean up millions of other dirty names from the voting rolls. In addition to all of our other work, defending voter ID, challenging the left's attack on clean elections generally in courts across the land. There is no private entity out there doing more to secure fair and clean elections over the last 2 decades than Judicial Watch. So you should support our work, right? Thanks for watching. Don't forget to hit that subscribe button and like our video down below.